I have seen a lot in my 27 years on the bench. I have seen men collapse before sentencing. I have seen mothers lie for sons they loved too much. I have seen innocent people tremble and guilty people grin. And I can tell you this with absolute certainty. The loudest person in a courtroom is almost never the strongest one. The morning this young man walked into my courtroom, the wall clock above the clerk's station read 8:43 a.m. courtroom 4B was cold, the way older criminal courts always are. The vents hummed. A deputy near the back shifted his weight, leather belt creaking. Somebody in the gallery unwrapped a cough dropped too loudly. And the defendant, 19 years old, red varsity jacket over a gray hoodie, hair cut sharp at the sides, chin lifted just a little too high, looked around like he was stepping onto a stage. Not into court, onto a stage. Before I even called the case, he leaned toward the young man beside him and said, not quietly enough, relax. I know my rights. I looked down at the file. Case number 24, CRM 1187. State versus Caleb Mercer. Reckless driving. Resisting without violence. Disorderly conduct. Interference with a public safety officer. At first glance, it looked like another young defendant who had confused confidence with understanding. But a judge learns not to trust first glances. First glances are for spectators. Facts are for the bench. And that's when everything changed. Because clipped to the inside of that file was a yellow evidence tab added at 7:56 a.m. that morning. Late evidence. Body camera enhancement. Supplemental digital recovery. I had not seen the contents yet. Neither had the gallery. Caleb Mercer certainly hadn't. And he was still smiling. Some details in this story are dramatized, but the lesson is true to the kinds of moments courtrooms see every day. I adjusted my glasses and said, call the case. The clerk stood. Case 24, CRM 1187, State versus Caleb Mercer. He approached the defense table with the slow swagger of someone who had practiced not looking nervous. But I notice hands. Hands tell the truth. His left hand kept flexing. His right thumb rubbed the seam of his jacket pocket. Fear was already there. Pride was just standing in front of it. His public defender, Ms. Keene, was prepared, organized, and already tired of him. I could see that too. Her legal pad had 3 clean columns. His copy was folded, crumpled, and untouched. The prosecutor, Mr. Salazar, rose with that measured, calm good prosecutors have when they know they do not need drama to win. Officer Dana Ruiz sat in the front witness row in full patrol uniform, back straight, face unreadable, mid-40s, bronze badge polished. Not a word wasted. The kind of officer who writes reports in complete sentences and irons his own sleeves. Behind him sat Mrs. Evelyn Hart, the civilian complainant. 63, school crossing guard, blue cardigan, left wrist wrapped in a tan support brace. That detail mattered. I began the way I always do. Mr. Mercer, you are here on misdemeanor charges arising from an incident on January 14th at approximately 7:18 p.m. near Lincoln and West Palmer. Do you understand the charges against you? He gave me a quick nod, then a half smile. Yes, sir. And for the record, I know my rights. There it was again. Not said with dignity. Said like a challenge. A few people in the gallery shifted. The deputy by the wall turned his eyes toward me, waiting. I kept my voice even. That is good, Mr. Mercer. Everyone in this room should know their rights. The question before me is whether you know your responsibilities. For the first time, his smile tightened. What happened next made the whole courtroom go silent. Because instead of shrinking back, he leaned toward the microphone and said, my responsibility is not to let cops violate me because they got an attitude. His lawyer closed her eyes for half a second. A half second can say a lot. Mr. Mercer, I said, you will speak through counsel unless I address you directly. He sat back hard in his chair. The metal legs scraped the floor. Officer Ruiz never moved. Mr. Salazar stood. Your Honor, the state is prepared to proceed. The defendant rejected pretrial diversion last month. We are now prepared to present the recovered digital evidence and call our first witness. Now, that was important. He had already been offered a way out. Diversion. A lane built for young offenders who make one stupid choice and want to leave with a lesson instead of a record. He had rejected it, which meant either he felt innocent or invincible. And I have seen young men ruin themselves because they could not tell the difference. Ms. Keene rose. Your Honor, the defense position remains that this stop escalated because Officer Ruiz unlawfully prolonged detention after a traffic infraction. My client's words may have been disrespectful, but disrespect is not a crime. That was true. Disrespect is not a crime. A courtroom should never punish attitude alone. If it did, we would have to jail half the internet. I nodded. Proceed. Mr. Salazar called Officer Ruiz. He took the stand, was sworn in, and settled into the witness chair with the kind of stillness juries trust. Even without a jury present, it mattered. Truth often has posture. Officer Ruiz, the prosecutor said, take us to the evening of January 14th. At approximately 7:16 p.m., I observed a black Dodge Charger traveling eastbound on Lincoln Avenue at what appeared to be a high rate of speed in an active school crossing zone. My radar indicated 43 miles per hour in a posted 20. I initiated a stop. The vehicle pulled over near the crosswalk. Then what? The driver, later identified as Caleb Mercer, immediately exited the vehicle despite repeated commands to remain inside. He was holding a phone up, recording me. Mr. Salazar glanced at the bench. Did he say anything? Officer Ruiz answered without emotion. Yes, he said, I know my rights. You can't tell me what to do. Caleb laughed under his breath. Not loudly, but enough. I looked at him once. He stopped. Officer Ruiz continued. I instructed him 3 times to return to the vehicle. Instead, he moved backward toward the crosswalk area, continued yelling, and failed to provide his license when requested. Did he make physical contact with anyone? Yes. During the interaction, he struck Mrs. Hart's safety clipboard with his arm while turning toward his camera. She stepped back and stumbled against the curb. Mrs. Hart lowered her eyes. There is a particular silence that comes when arrogance meets an elderly person's injury. It has weight. Ms. Keene stood for cross-examination. She was good enough to make a truthful witness work for every inch. Officer Ruiz, my client did not punch anyone, did he? No, he did not threaten to kill you. No, he asked if he was being detained, correct? Yes. And you never answered that question directly on the initial footage we reviewed in pretrial, correct? Officer Ruiz paused. Not in the first segment, no. Thank you. And when he pulled away from your grip, that was after you reached for him, right? Yes. So physical escalation began with you. No, Ruiz said. Physical control began with me after repeated refusal to comply inside an active crossing lane. That was a good answer. But the defense had landed something. I could feel it. A couple people in the gallery were already leaning toward Caleb's side. Young defendant, camera phone, officer making contact. Those facts can move a room fast. And that's when the next details stopped the room cold. Mr. Salazar said, Your Honor, with the court's permission, the state would like to publish Exhibit 6, the recovered social media live stream cache from the defendant's own phone, restored by the digital forensics unit at 6:12 a.m. today. Caleb's head turned, just slightly. That was the first real crack. Ms. Keene looked at him. He did not look back. I allowed it. The monitor angled toward the bench flickered on. The courtroom speakers hissed once. Then the video began. Vertical frame. Front-facing camera first. Inside the Charger. Dash lights glowing blue across Caleb's jaw. Timestamp. 7:15 and 42 seconds p.m. He was talking to his viewers. Laughing. Music low in the background. Watch this, he said into the camera. If this dude lights me up, I'm getting paid. I swear I need one dumb cop tonight. Just one. No one in the room moved. The clip continued. Red and blue lights flared behind his windshield. He grinned, actually grinned, and said, There we go. Then he propped the phone, cracked his neck, and stepped out before the car had fully settled. Officer Ruiz's voice came through the recording. Driver, stay in the vehicle. Caleb aimed the phone right at him and said, Nah, I know my rights. Then, lower, to the camera, not to the officer, he muttered, Clip this. Clip all this. The sound in my courtroom changed after that. You could hear clothing move, a chair shift. Mrs. Hart inhale through her nose. Even the defendant's attorney stopped writing, because this was no longer a frightened teenager standing up for himself. This was a young man auditioning for outrage, and he had nearly turned a school crossing into content. If you like courtroom stories where one piece of evidence flips everything, subscribe now, because the next turn in this case hit even harder. Miss Keene asked for a sidebar. I denied it. The record was the record. The prosecutor continued the video. Now the camera had switched outward. It shook wildly as Caleb walked backward while arguing. Officer Ruiz, return to the vehicle. Caleb, am I detained? Am I detained? Say it right. Say it right. Officer Ruiz, yes, you're detained. That mattered too, because the defense argument had just weakened. Then the video jerked left. And there, at the edge of frame, was Mrs. Hart in her reflective crossing vest, one hand up, trying to get clear. Caleb swung his elbow as he turned toward his camera. The clipboard flew. She stumbled. The audio clipped. And what happened next made the whole courtroom go silent all over again, because another voice, a young, frightened female, came through the stream from across the street. Caleb, stop. My little brother's right here. Mr. Salazar froze the frame. A boy in a green backpack stood at the curb no more than 8 feet away. Small, maybe 10 years old. Watching all of it, I felt my jaw set. Court changes when children enter the facts. Not theoretically. Actually, the prosecutor spoke softly now. He did not need force. Officer Ruiz, was the crossing still active when you initiated contact? Yes. And why did you physically restrain the defendant? Because he kept moving into a pedestrian lane while filming, ignoring commands, and I believe someone was about to get hurt. Did someone get hurt? Mrs. Hart suffered a wrist sprain when she fell back. Mr. Salazar sat down. The defense had to stand into bad weather now. Miss Keene did what professionals do. She kept going. Officer Ruiz, the defendant is 19, correct? Yes. Smaller than you? Yes. Nervous? He looked excited. A few muffled reactions moved through the gallery. She changed direction. Did you at any point strike him? No. Did he strike you? He pulled away and clipped my body camera mount. So this became a resisting case based largely on noncompliance and movement. Yes, in a hazardous area. That answer held. Then Miss Keene did something smart. She called Caleb. I'll say this for her. She understood the only chance left was humanity. If the law would not save him, maybe honesty could. He took the stand with less swagger than before. The jacket seemed too bright on him now. His knee bounced under the witness rail. She asked the gentle questions first. Caleb, how old are you? 19. Are you employed? Part-time. Tire shop. Any prior felony record? No. Why did you say what you said to Officer Ruiz? He swallowed. Because people get pushed around. Because if you don't say anything, they do whatever they want. There was something real in that answer. Not enough, but something. Then she asked, did you intend to hurt Mrs. Hart? No, ma'am. I didn't even see her at first. That I believed. Not seeing her was the problem. Not hatred. Vanity. He had entered that moment seeing only himself and the camera. Miss Keene took one more step. Did you understand the seriousness of what you were doing? He hesitated. And for 1 second, one precious second, I thought he might tell the truth. Instead, he looked toward the gallery, then toward me, and said, I still know my rights. I just think this got blown up. There it was. Again. Pride arriving to rescue him from accountability. Only this time, it sounded smaller, sadder. I leaned forward, very slightly. Mr. Mercer, I said, you keep using that phrase as though it is a shield. Rights are not magic words. They do not erase speed. They do not erase danger. They do not erase a woman falling backward near a curb while a child watches. He looked at me, jaw working. I continued, quieter now. You know the words. You do not yet know the weight. That landed. Even Caleb's own friend in the gallery stopped looking at his phone. But the case was not over, because Mr. Salazar stood again and said, Your Honor, one final exhibit. State's Exhibit 9. Miss Keene looked surprised. So did I. Proceed, I said. He held up a printed still frame from a school security camera mounted above the crossing signal. Timestamp, 7:16 and 58 seconds p.m. The image showed Caleb's Charger rolling forward approximately 3 feet after he had exited. Not much, but enough. Gear had not been fully set. The front bumper had drifted into the edge of the marked crossing while he was filming himself. That was the unseen danger. Not just his mouth. His negligence. He had stepped out so fast, so eager to perform. He had failed to secure a running vehicle next to a child crossing lane. Mrs. Hart put a hand over her mouth. And that's when everything changed for the last time. Because Caleb finally looked like a teenager. Not a provocateur. Not a live stream tough guy. A teenager. His face lost color. He turned toward the screen and whispered, I thought I put it in park. No one answered. The deputy near the wall looked at the floor. His lawyer set her pen down. Officer Ruiz stared straight ahead. That moment matters more than people realize. It is the exact second a defendant stops fighting the courtroom and starts hearing it. I asked the question every judge asks when truth finally walks in. Mr. Mercer, do you wish to continue testifying? He stared at the screen another second. Then he said, no, sir. The state rested. The defense did not call another witness. Arguments were brief after that. Miss Keene did the honorable thing. She did not excuse him. She contextualized him. Your Honor, Mr. Mercer acted with immaturity, ego, and recklessness. But he is 19, employed, with no felony history and no evidence of intentional violence. The defense asks the court to balance accountability with the possibility that this young man can still learn before the system hardens him permanently. That was well said. Mr. Salazar rose next. The state agrees this defendant need not be destroyed, but he does need to be stopped. He turned lawful detention into a public performance, endangered a crossing zone, and treated basic civic order like a joke. We asked for a sentence that teaches him consequences are real before someone dies. I took off my glasses. When I do that, people pay attention. The room stilled. At 9:11 a.m., I delivered the ruling. On the charge of reckless driving, the court finds the defendant guilty. On the charge of disorderly conduct, guilty. On the charge of interference with a public safety officer, guilty. On the resisting charge, guilty as amended to resisting without violence. Caleb closed his eyes. His mother, who had arrived late and sat in the back without saying a word, covered her face with both hands. I let the silence hold for a moment. Then I said the part that mattered most. Mr. Mercer, this court is not interested in ending your life. It is interested in ending your excuses. He opened his eyes. I continued. You are sentenced to 30 days in county jail, suspended. 12 months of supervised probation. Your driver's license is restricted for 6 months for work and court-approved travel only. You will complete 160 hours of community service, half of it in a city pedestrian safety program. You will complete a certified civic responsibility course and a victim impact panel. You will pay restitution for Mrs. Hart's medical costs. And before you leave this courtroom today, you will apologize not to perform, not to impress me, but to practice telling the truth out loud. He swallowed hard. Then I added one more condition. If you complete every term without violation, this court will entertain a motion to reduce the impact of this conviction at the appropriate time. If you treat probation the way you treated that crosswalk, I will not be this generous twice. That line stayed in the air. Heavy. Exact. Final. Then I turned to him directly. Do you understand your sentence? His voice was different now. Lower. Stripped of audience. Yes, sir. Do you understand why you received it? A long pause. Then, because I thought being loud was the same as being right. Now that was the first honest sentence he had spoken all morning. And after value, I'll ask you this. If that line hit you, leave a like and tell me in the comments whether Caleb deserved grace, jail, or both. I nodded toward Mrs. Hart. Stand and say what needs to be said. He rose slowly. The red jacket seemed to weigh 10 pounds. He turned toward her. His mouth opened once, closed, opened again. "I'm sorry," he said, "for hitting your arm, for the car, for acting like a clown. I didn't think about anybody except myself." Mrs. Hart looked at him for a long second. People expect old witnesses to want revenge. Most of the time, they want honesty. She gave a small nod. "Then think next time." That was all. No speech. No tears. Just truth in a sentence. Most people think the story ends there. Gavel. Sentence. Lesson. Fade out. But courtrooms do not end lives in neat little scenes. They interrupt them. Sometimes that interruption becomes a collapse. Sometimes, if a person is lucky and humble enough, it becomes a turn. 6 months later, on a review calendar packed with probation updates and compliance checks, I saw Mercer. Caleb listed again at 10:34 a.m. He walked in wearing a plain white button-down and cheap black slacks. Hair trimmed. No audience. No friend. No red jacket. The deputy at the door didn't even recognize him at first. When he reached counsel table, he stood straight. Not stiff. Just steady. Probation reported perfect attendance. Community service completed ahead of schedule. Restitution paid. No new charges. Civic course certificate submitted. Victim impact panel completed. Mrs. Hart had even filed a short note with the clerk. Not forgiveness. Something better. Confidence. It read, he showed up. He worked. He listened. I looked at him and asked, "How is the pedestrian safety program?" He answered, humbling. A few quiet laughs moved through the courtroom. Then he said something I still remember. "Your Honor, the first day they made me help kids cross before school, and one of them ran ahead without looking. I grabbed his backpack, and all I could think was, that could have been because of me. Not hypothetically. Actually, because of me. There it was. The difference between being caught and being changed. One makes you quieter. The other makes you deeper. I reduced one reporting condition that day, nothing more. Grace should never arrive so fast it looks like forgetfulness." Before he turned to leave, he stopped and said, "And for the record, I do know my rights now." The room got very still. Then he added, "I just finally learned they don't cancel consequences." I let myself breathe once through my nose. "Good," I told him. "That is the beginning of adulthood." He nodded and walked out. No grin. No performance. Just a young man carrying the weight he should have carried the first time. Here's the lesson, and I will keep it short. Knowing your rights is a good thing. It matters. It protects people from abuse, from overreach, from fear dressed up as authority. No judge worth the robe would ever mock that. But rights are not a costume for ego. They are not a shortcut around responsibility. And they are certainly not a defense for turning danger into entertainment. The truth is, most people do not get ruined by one bad moment. They get ruined because pride will not let that moment teach them. Accountability is not cruelty. Grace is not weakness. And the strongest people I have seen in court were never the ones who said, "You can't tell me anything." They were the ones who finally said, "I was wrong." This is a dramatized courtroom story, but that principle is as real as any sentence I have ever handed down. If you want the next story, watch the one where a father laughed through arraignment until a quiet witness stood up in the back row and changed the case in under 30 seconds.